Good afternoon, and I'm joined again by Mr. Jon Sharp for another one of his 10-minute takeaways, and we are still talking about COVID-19 and the insurer's response. Good afternoon, Jon.
Good afternoon, Julie. How are you?
I'm good, thank you. How's the weather in Scotland?
It's very rainy at the moment, and we're threatened with snow tomorrow.
Oh dear Lord, it just continues. The joys of January. Okay, so the Supreme Court have now ruled on insurers' liability to pay business interruption as a result of COVID. What was at the case's heart, Jon?
Well, really, at the case's heart, when it boils down to it, was this. I think you're familiar with my fish and chip shop example, but I'm going to repeat it because it's a good one, and it's not just because I like fish and chips. Let's assume you've got your fish and chip shop in the middle of, say, 4 or 5 villages. You're doing very well, lots of trade. When you opened the shop, you would have taken out some form of cover to cover your fish and chip shop in the event of fire or flood. Yeah. And this would have been, now, just assume this was a basic policy which covered you for fire and flood. One of your fat fryers catches fire and the chip shop burns down or is badly damaged by fire. There's no issue. Insurers say, fine, you're covered for fire, we will come and repair the building. That's fine. But at the same time, even in the most basic policy such as that, there would have been some business interruption cover provided. So for the time that the premises are being repaired, you will get some money, either by way of an equivalent to the amount of turnover you would have made whilst the businesses are being repaired, or an amount of loss of profit. But you'd have got some form of business interruption payment. Okay? Now, all basic policies did that. Now, however, the more money you paid, you sometimes got these quite sophisticated policies which covered you for a whole other set of eventualities, including notifiable disease, and if your premises have to be closed by actions of government or local authorities. Now, insurers said this pandemic is very similar to a case called the Orient Express case, which again I've mentioned before. This was a hotel that was in New Orleans and was physically damaged by Hurricane Katrina and subsequently, I think, by another hurricane, Hurricane Rita. So she got a double pounding, and as a result of that, the hotel was very badly damaged and had to be closed. Now, whilst the damage was repaired. Now, you would have thought, using my fish and chip shop example, that they would also have had some business interruption payments made to them, whether it be loss of turnover or loss of profit. But the court said in that case, no, because there was no business to interrupt effectively. The whole of New Orleans was in lockdown. No one was allowed to go. I think at one stage there was outbreaks of cholera and all sorts of things. So nobody was going. So there was no business to interrupt. And that's what insurers relied on in defending the FCA's case, which was brought effectively on behalf of policyholders, saying it's the same as the Orient Express case. Now, at first instance, Mr. Justice Flo obviously considered that this case, and he said, no, that case was decided wrongly. It would certainly be decided differently now, and he overruled it. Now, when it went to the Supreme Court, obviously, the same arguments were run again. Now, in terms of the appeal to the Supreme Court, most parties appealed, with the exception, as I think before I've said, of ecclesiastical, whose policies at first instance were found not to have cover, Zurich, who had 4 policies before the court, only one of which was found to have cover, and Zurich said, stick, we'll stay where we are, thanks very much. But others, as again I've said before, fared very badly. Hiscox, every single one of their policies was found to have cover, and therefore they all wanted to appeal. And the FCA also wanted to appeal because it felt that whilst the first instant judgment was very favourable for policyholders, it hadn't quite gone far enough in terms of ensuring that insurers pay. So it all went up to the Supreme Court, and the Orient Express case was again looked at, and this thing was very firmly overruled.
What then did the Supreme Court decide?
Well, the Supreme Court looked at basically 5 areas. It looked at the disease clause. These are outbreaks of a notifiable disease either at the premises or within a radius of the premises. It looked at the prevention of access and hybrid clauses. So these are the clauses that say we will pay out in the event that your premises are forced to close because of the actions of government, local authorities, etc. It looked at causation. So what actually should the policy be responding to? What was the cause of the loss? It looked at what called trends clauses. I'll explain that a little bit in a minute. Also looked at pre-trigger losses, as well as obviously the Orient Express case, but I've already discussed that. So what did it decide? Well, in relation to disease clauses, the court ruled that all occurrences of COVID-19 played their role in the government's response to the pandemic, meaning that if a policyholder can demonstrate that a case of COVID-19 had occurred within a specified distance of its premises, cover is provided under the policies. It's slightly annoying that the courts didn't consider a breakout at the premises. But they may have felt that if there's a breakout within a radius of the premises, that's probably enough. It would have been nice if they touched on that. However, the court, and this is also annoying, the court has not given guidance as to the type of evidence that a policyholder needs to show to its insurers to show that there was an outbreak within a specified radius. However, again, credit to the FCA. They have put some guidance on their website as to what you should, what you should only have to show to insurers. And a policyholder's personal knowledge, together with some evidence, plus some media support, should be enough to prove that there was an outbreak within. Okay. In relation to the prevention of access, these clauses that say government action, local authority action, etc. What they decided was that an instruction given by a public authority may amount to a restriction imposed if it carries the imminent threat of legal compulsion or is in mandatory and clear terms and indicates that compliance is required without recourse to legal powers. So that more or less does cover our situation. This is where the government said, do not go to your office, work from home, offices should close. Now, they may not have passed a specific law to say, but if everyone said, oh, we're not going to ignore you, government, and kept their offices open, they would have done. They'd have passed the law. So I think that covers it. And this is a widening of the interpretation from the first instance, which means that policyholders who received instructions of this nature from a public authority will be deemed to have cover. Now, causation. Well, obviously, the insurer said there's a number of causes. We can't possibly decide which one actually caused the business interruption, loss, etc. And of course, the Supreme Court said no. Was held that policyholders would be covered for losses where there is a causal connection between the insured peril, the pandemic, and the business interruption. The fact that there were other uninsured causes, such as a downturn in business due to the impacts of coronavirus on public confidence, etc., should also contribute to the loss, does not exclude cover. So cover's there. As regards trends clauses and pre-trigger losses, trends clauses are designed to ensure that the quantum of an insurance claim properly reflects the level of cover provided. And what the court said, and this is very good in the judgment, is they gave an example, a bit like my fish and chip example. I wonder if they've been listening to my vlogs, Julie. Unlikely, but there we are.
I am sure they have, John.
Well, there we are. And what they referred to was they gave an example of a restaurant whose star chef is due to leave for reasons unrelated to the pandemic. So he's just had a bit of a tiff and he's off somewhere else. Yeah. It would be unreasonable for the insurer to indemnify for any loss of turnover which would have resulted from the loss of the star chef in those circumstances, which I think we'll all agree with, just because he's decided to leave very tough. However, any losses arising from the pandemic are inextricably linked, and the Supreme Court took the view that attempt to separate this would be artificial and unrealistic. So your star chef is off because of reasons related to the pandemic, or COVID-19, because he was told not to come to work. Perhaps he had COPD and therefore had to self-isolate. I'm sorry, you're paying for that. Okay. So policyholders are therefore covered for all losses arising as a result of the pandemic, including, by way of example, any losses which might have been caused by a downturn in business due to the pandemic.
Okay, so what is your advice now, John?
Well, my advice really hasn't changed since my last vlog. There are still problems without any shadow of a doubt. Let's not just start thinking this is all going to be a walk in the park now. It's not. Excuse me. If you are lucky enough to have one of those policies which has been looked at by the court and where cover was found to exist, your insurers should be writing to you now saying, this is how we're going to deal with your claim going forward. That's what the FCA have asked them all to do. However, as I've said before, there is a huge, another 50 or 52 policy wordings out there which were not considered by the court. Now, some of the clauses in there will have been considered by the court, no two ways about it. Yeah. But if you have one of those that wasn't considered by the court, my strong advice to you would be to, and it's got a business interruption clause in it, get some legal advice. There is now a template to measure that clause against. Now, as you know, Julie, our own policy is one of those that wasn't considered by the court. And I'm afraid I've done exactly as I'm advising everybody else to. I've sent it to council to say, this is our policy, does it respond? And it's not going to cost a great deal of money to do that because there's now something to measure it against. Two clear, decided judgments. But it's not going to cost an absolute fortune. The problem is, and I've been saying this for a while now, that if you do now suddenly think, oh, I wonder if my policy did have business interruption, and you try to make a claim now, insurers are undoubtedly going to say it's late notification. And to be fair, with some justification. I mean, a friend of mine's got a parrot, and he keeps his parrot in the lounge. And when the television's on, it sometimes mimics. If it hears the same word repeatedly, it sometimes mimics what's on the telly. And even it's learned COVID-19. So insurers not unreasonably are going to be turning around saying, where have you been for the last year?
Yeah.
So I do fear, yeah, fair point. I do fear that if you haven't made a claim within a couple of months, you are going to be faced with a late notification argument.
Yeah.
And I have got, sympathy with that. I'm not saying I haven't. So you need to check. You need to take some advice if you're not sure, but also speak to your broker. They will also be given guidance by the FCA, I suspect, as well. And then, of course, you've got to start putting together your claim. Now, this is where we are going to have the second battle, because it will all be to do with quantum.
Yeah.
Insurers will be saying, okay, yeah, there is cover. Now, what exactly did you lose? Now, you've got to prove that. So they will admit liability. So, yeah, okay. But come on, what have you actually lost? What are you going to be able to prove to us that you lost under the terms of the policy? Now, to some extent, I'm almost thinking to myself, if I was an insurer, I would have probably taken that stance from the start. A couple of brokers I've spoken to have said that they were surprised they didn't either, because they could have saved themselves all the adverse publicity that they've had. And if they just said, look, okay, what have you lost? Prove it. That would have, everyone would have gone, oh, okay, right, now. So we're going to have lots of issues regarding quantum. This is not over yet. Now, there is guidance on the FCA website, but it primarily relates to no fault of the FCA's, who I commend again for the transparency of all of this. So they are only giving guidance really as how to get insurers to admit liability.
Yeah.
Issues as to quantum haven't really been looked at yet. And I suspect there will be a second round of litigation which will deal with quantification of losses. There may well still be some litigation as regards liability with regard to these other 52 policies. Well, I think insurers will probably think if there is some form of cover in the policy, the best thing to do now is to say, okay, yes, fine, but fight on quantum. And they will fight ferociously on quantum.
Yeah.
There are some 300, what is it? 370,000 policyholders potentially affected. And it's going to cost the insurance industry, if they all pay the claims, that 1.8 billion.
Wow.
And they'll be doing all they can to get that 1.8 billion down.
Yeah.
So, as I said right at the beginning when we started this first set of vlogs, and I said the FCA may well get involved, I did say to everyone, make sure you keep records. Don't throw anything away. You'll need to be comparing one year against another year. And it's now's the time to start getting together that claim and thinking about what you can actually claim for.
Yeah.
And what you can prove. So that's my advice at the moment, Julie. It is now all over as far as liability is concerned, as I said, apart from possibly litigation of the policies that were considered. But certainly the next battle is going to be quantum. And I'm sure we'll be finding one or two cases cropping up in the relatively near future with regard to this. And if there are, I will come back and update everyone then. But in the meantime, Julie, that's all I was going to say. And perhaps in the next 3 months, we might just have another one and just see how things have developed from there. But thanks as always, Julie. Thank you very much indeed.
No problem. Thank you for sharing your expertise and warning the quantum experts of the world they're likely to be a tad busy over the next.
They may well be a tad
couple of
busy because to some extent, yes, it will be a lawyer's job, but it will also be accountants' jobs.
Yeah.
And other proper assessors to deal with some of this. But at least now we're over the first hurdle, to some extent at least. Liability, yes, these policies are due to pay out. Quantum, going to be a different matter.
Okay. Right, we look forward to the next update. And we will see you soon on, you've got a couple of seminars coming up as well.
Have I?
One,
oh, yes, I have.
You have indeed. Don't do that to me. One on the Brexit effect, which is Wednesday morning, 17th of February. So if anyone would like to sign up for that, they can email us at seminars@silverllp.com, where they can hear more of your wisdom and knowledge on these subjects. So thank you very much, Mr. Sharp. We'll speak to you soon.
I'm sure I'll manage to read your policy wording into the Brexit one, Julie. It's not gone away.
I'm sure you will. Thanks,
okay,
John.
Julie.
Bye.
Thanks very much indeed.
Bye.
Take care. Bye-bye.